of the Rules of Court to hear the observations of the parties on the request for the indication of provisional measures submitted by the Republic of India in the Jadhav case, India versus Pakistan. For reasons which they have duly conveyed to me, the Vice President and Judges Tomka, Benuna and Greenwood are unable to be present on the bench today. India's application, dated the 8th of May 2017, instituting proceedings against the Islamic Republic of Pakistan, concerns alleged violations of the Vienna Convention on Consular Relations. I quote, "In the matter of the detention and trial of an Indian national," end of quote, "sentenced to death in Pakistan, Mr. Kulbhushan Jadhav. To found the jurisdiction of the court, India relies on Article 36, paragraph 1 of the Statute of the Courts and on Article 1 of the Optional Protocol concerning the compulsory settlement of disputes which accompanies the Vienna Convention. I shall now ask the Registrar to read out the decision requested of the Court as formulated in the application of India.
In the circumstances, India seeks the following reliefs. 1. A relief by way of immediate suspension of the sentence of death awarded to the accused. 2. A relief by way of restitution in interregnum by declaring that the sentence of the military court arrived at, in brazen defiance of the Vienna Convention rights and Article 36, particularly Article 36, paragraph 1b, and in defiance of elementary human rights of an accused, which are also to be given effect as mandated under Article 14 of the 1966 International Covenant on Civil and Political Rights, is violative of international law and the provisions of the Vienna Convention. And 3, restraining Pakistan from giving effect to the sentence awarded by the military court and directing to take steps to annul the decision of the military court as may be available to it under the law in Pakistan. 4, if Pakistan is unable to annul the decision, then this court to declare the decision illegal, being violative of international law and treaty rights, and restrain Pakistan from acting in violation of the Vienna Convention and international law by giving effect to the sentence or the conviction in any manner and directing it to release the convicted Indian national forthwith.
On the same day as the filing of the application, India submitted a request for the indication of provisional measures referring to Article 41 of the Statute of the Court and to Article 73, 74, and 75 of the Rules of Court. In that request, India states that the alleged violation of the Vienna Convention by Pakistan has prevented India from exercising its rights under the Convention and has deprived Mr. Jadhav from the protection accorded under the Convention. The applicant also submits that Mr. Jadhav, I quote, will be subjected to execution unless the court indicates provisional measures directing the government of Pakistan to take all measures necessary to ensure that he is not executed until the court's decision on the merits of the case." End of quote. India points out that Mr. Jadhav's execution would cause irreparable prejudice to the rights it claims. India further indicates that the protection of its rights is a matter of urgency as, I quote, "without the provisional measures requested, Pakistan will execute Mr. Kulbhushan Jadhav before the court can consider the merits of India's claims, and India will forever be deprived of the opportunity to vindicate its rights." End of quote. I shall now ask the Registrar to read out the passage from the request specifying the provisional measures which the Government of India is asking the court to indicate.
India respectfully requests that pending final judgment in this case, the court indicates: A. That the government of the Islamic Republic of Pakistan take all measures necessary to ensure that Mr. Kulbhushan Jadhav is not executed. B. That the government of the Islamic Republic of Pakistan report to the court the action it has taken in pursuance of subparagraph A. And C. That the government of the Islamic Republic of Pakistan ensure that no action is taken that might prejudice the rights of the Republic of India or Mr. Kulbhushan Jadhav with respect of any decision the court may render on the merits of the case.
On 8 May 2017, immediately after the filing of the application and request for the indication of provisional measures, the Registrar, in accordance with Article 40, paragraph 2 of the statute and Articles 38, paragraph 4 and 73, paragraph 2 of the Rules of Court, transmitted certified copies thereof to the government of the Islamic Republic of Pakistan. He also notified the Secretary General of the United Nations of the filing of these documents by India. By a letter dated the 9th of May 2017, referring to Article 74, paragraph 4 of the Rules of Court, in my capacity as President of the Court, I called upon the Islamic Republic of Pakistan, I quote, to act in such a way as will enable any court the court may make on the request for indication of provisional measures to have its appropriate effects. End of quote. According to Article 74 of the Rules of Court, a request for the indication of provisional measures shall have priority over all other cases. Referring to the, I quote, the extreme gravity and immediacy of the threat, end of quote, India asked the court to render an order on its request without a hearing. The court decided to hold a hearing in order to allow both parties to present their arguments. Given the circumstances, the court decided that the oral proceedings contemplated in Article 74, paragraph 3 of the Rules of Court should be brief and held on rather short notice on 15th May 2017, today. I note the presence before the court of the agents and counsel of the two parties. The court will hear India, which has submitted the request, this morning until 11:30 a.m. It will hear Pakistan this afternoon from 3 to 4:30 p.m. The hearings on India's request for the indication of provisional measures will be closed at the conclusion of this afternoon's session. For the purposes of these oral arguments, each of the parties will have available to it a full 90-minute sitting. India may, if required, avail itself of a short extension beyond 11:30 a.m. this morning, in view of the time taken up by the opening part of these oral proceedings. The parties are, of course, not required to use the full amount of time allotted to them. Before giving the floor to the agent of the Republic of India, Dr. Deepak Mittal, I wish to draw attention to Practice Direction 11, which states inter alia that parties should, I quote, in their oral pleadings on requests for provisional measures, limit themselves to what is relevant to the criteria for the indication of provisional measures as stipulated in the statute, rules and jurisprudence of the court. They should not enter into the merits of the case beyond what is strictly necessary for that purpose. End of quote. I now call upon Dr. Deepak Mittal, agent of the Republic of India.
Mr. President and honorable members of the court, it is indeed a great honor for me to appear today before this august court on behalf of the Republic of India as India's agent at the oral hearings on India's request for indication of provisional measures in the proceedings instituted by India against the Islamic Republic of Pakistan on 8 May 2017. This case concerns an Indian national, Mr. Kulbhushan Jadhav, who has been awarded death sentence by a military court in Pakistan in egregious violation of the rights of consular access guaranteed by Article 36, Paragraph 1 of the Vienna Convention on Consular Relations 1963. At the outset, I would like to thank the court and the President for the timely decision and action to exercise the powers conferred upon him under Article 74, Paragraph 4 of the Rules of Court and send an urgent communication on 9 May to the Prime Minister of the Islamic Republic of Pakistan, calling upon the government of Pakistan to act in such a way as will enable any order the court may make on India's request for the indication of provisional measures to have its appropriate effects. Mr. President, members of the court, the fact that the hearing is taking place today within 7 days of the institution of proceedings by India is testament to the recognition of the urgency by the court in the case of an innocent Indian national, Mr. Jadhav, who, incarcerated in Pakistan for more than a year on concocted charges, deprived of his rights and protection accorded under the Vienna Convention, being held incommunicado without contact with his family and the home state, is facing imminent execution. All notions of human rights are now considered by the global community as basic to behavior in civilized nations have been thrown to the winds. By this timely action by the President and the court, this institution has provided succor not just to India and to its beleaguered national and his family, but also has given hope to 1.25 billion people of India and hope to the old mother and father of the innocent Indian national that justice would be meted out to their innocent son. By this highest seat of justice and a precious life will be saved. Today, accompanied by my colleagues, I appear before the court on behalf of the Republic of India with the hope that the court would indicate provisional measures so that the death sentence which has been awarded to Mr. Jadhav through a farcical trial in a Pakistan military court in violation of the rights guaranteed to Mr. Jadhav and India under Article 36, Paragraph 1 of the Vienna Convention would be set aside and not carried out pending final decision of the court on India's application. I take this opportunity to introduce the members of my delegation. They are Mr. V.D. Sharma, co-agent, Mr. Harish Salve, counsel, Ms. Kajal Bhatt, Advisor, Ms. Chetna Rai, Junior Counsel. I would now present brief facts of the case, which would be further elaborated upon during the hearing. India was informed on 25 March 2016 that an Indian national was allegedly arrested on 3 March 2016. India, on that very day, sought consular access to the said individual. The request did not evoke any response. On 30 March 2016, India sent a reminder reiterating the request for consular access at the earliest. Despite a number of such reminders for consular access sent by India, there has been no response and all these requests fell on deaf ears. Meanwhile, on 23 January 2017, India received from Pakistan a request for assistance in investigation process. Subsequently, on 21 March 2017, almost a year after India's first request for consular access, Pakistan formally communicated to India that consular access to Mr. Jadhav, I quote, shall be considered in the light of Indian side's response to Pakistan's request for assistance in the investigation process, unquote. India responded that consular access would be an essential prerequisite in order to verify the facts and understand the circumstances of Mr. Jadhav's presence in Pakistan. On 10 April 2017, India learned from press reports that Pakistan proceeded to have a military trial against Mr. Jadhav, and he was sentenced to death purportedly on the basis of a confessional statement, and that this sentence was confirmed by the Chief of the Army Staff of Pakistan. Ironically, later in the day, after that sentence has been awarded and confirmed, India received a note verbal from Pakistan reiterating the condition for considering consular access in return for India providing assistance in the investigation process. India responded the same day, highlighting that the offer of conditional grant of consular access after award and confirmation of death sentence reflected the farcical nature of the proceedings and the so-called trial by a Pakistan military court against Mr. Jadhav. Despite requests by India, Pakistan has not provided any information or documents, including the charge sheet, proceedings of the court of inquiry, the summary of evidence, the judgment. Request for appointment of a defense lawyer for Mr. Jadhav has also not elicited any response. The mother of Mr. Jadhav, even in the absence of any document, submitted an appeal to the Court of Appeal and a petition to the federal government of Pakistan. This appeal was filed even though it was unable to address any of the issues that may have been put against Mr. Jadhav in the judgment and order of conviction. It was an act of desperation by grieving parents. The parents of Mr. Jadhav applied for visa on 25 April 2017 to travel to Pakistan. There has been no response. The Minister of External Affairs of India has written to the advisor to the Prime Minister of Pakistan on Foreign Affairs on 27 April 2017 for his personal intervention in the matter, but there has been no response. All that we know is what we have seen in the media in Pakistan. Pakistan officials have been reported as having said clearly that Mr. Jadhav would not be provided consular access. Mr. President, members of the court, India believes that the farcical nature of the proceedings and unjust trial by a Pakistan military court in egregious violation of the rights of consular access under the Vienna Convention has led to serious miscarriage of justice. It is clear that Mr. Jadhav has been denied the right to be defended by a legal counsel of his choice. He has not been informed of his right to seek consular access. His conviction and death sentence appears to be based upon quote-unquote confession taken in captivity without proper legal representation and in absence of consular access sought by India. If we closely follow the reports in the media in Pakistan, we can get the sense that an increasing number of death sentences awarded by military courts in Pakistan have been carried out after 10 April 2017. That's when the death sentence to Mr. Jadhav was confirmed. In fact, over the past 1 month, 18 such executions have been reported through press releases issued by the Inter-Services Public Relations, the military spokesman of Pakistan. In such circumstances, including where there is no response to the requests made through diplomatic channels, there is an immediate threat that death sentence against Mr. Jadhav may be carried out even before India has the opportunity to be heard and the court has a chance to consider the merits of the case, and thus causing irreparable prejudice to the rights of India and Mr. Jadhav. Mr. President and the members of the court, India has invoked the jurisdiction of the court and sought provisional measures. My colleagues will elaborate further on this. I would now request the court to invite Mr. V.D. Sharma, co-agent for the Republic of India, to make his submissions. Thank you.
Merci, monsieur. Avant de donner la parole au co-agent de la République de l'Inde, le Dr Sharma, je demanderai aux plaideurs de bien vouloir ne pas parler trop vite, de manière à permettre aux interprètes de faire leur travail de traduction dans l'autre langue officielle de la Cour. Je les en remercie d'avance. Monsieur le Dr Sharma, co-agent de la République de l'Inde, vous avez la parole.
Mr. President, distinguished members of the court, it's a great honor for me to appear before this court as co-agent of the Republic of India in the case concerning the violation by the Islamic Republic of Pakistan of the Vienna Convention on Consular Relations, 1963. I propose to devote my observations to the key issues which would be addressed in elaboration by my colleague Mr. Harish Salve concerning violation by Pakistan of the rules of international law which led to the dispute at hand, justification for the grant of urgent provisional measures, and this court's jurisdiction. Now, Mr. President, I draw your attention to paragraph 5 of my statement in front of you. Mr. President, members of the court, the convention sets up, among other things, standards of conduct concerning consular relations between states, with the view to contribute to the development of friendly relations among them. The provisions under Article 36 of the Convention specifically confer rights of consular access and communication upon the sending states and their nationals, who may be arrested, detained, or put in prison in the receiving state. These provisions were interpreted by this court in the Lagrand case, Germany versus United States, and reiterated in the Vienna case by this court, what this court said in the Lagrand, and described Article 36, paragraph 1 as an interrelated regime designed to facilitate implementation of the system of consular protection and set out again the scheme of Article 36. Mr. President, members of the court, Article 36, which has been recognized as a right of the national of a state and also the right of the state itself, is a vital safeguard that ensures a modicum of fairness in the administration of justice system of a state in its application to nationals of another state. Its provisions are sacrosanct and its violation entails serious consequences. Mr. President, members of the court, Pakistan failed to comply with all its obligations under Article 36. It denied India its right to consular access and to its nationals. India has been seeking consular access incessantly since March 2016, when India was informed of the detention of Mr. Kulbhushan Jadhav by Pakistan. Touching upon the jurisdiction of this court in the present case, the attention is drawn to Article 36, paragraph 1 of the statute of the court, which confers upon the court the jurisdiction to decide all matters specifically provided for in treaties and conventions in force. Therefore, India relies upon the jurisdiction of this court under paragraph 1 of Article 36 of the statute of this court. India asserts that the declarations of Pakistan and India made under paragraph 2 of Article 36 of the statute have no relevance to this case. India and Pakistan are members of the United Nations and thus ipso facto parties to the statute of the International Court of Justice. They are also a party to the Vienna Convention and its optional protocol concerning compulsory settlement of disputes. Article 1 of the optional protocol provides that disputes arising out of the interpretation or application of the convention shall lie within the compulsory jurisdiction of the International Court of Justice and may accordingly be brought before the court by an application made by any party to the dispute being a party to the present protocol. I know, Mr. President and members of the court, draw your attention to paragraph 14 of my statement. India and Pakistan are both parties to the Consular Convention and the optional protocol, and thus this dispute lies within the jurisdiction of this court and has been brought accordingly before the court by India. Now, Mr. President, I draw your kind attention to paragraph 16 of my statement. There is a bilateral agreement between India and Pakistan that seeks to supplement in some respects Article 36 of the Vienna Convention. India does not seek to rely upon this bilateral agreement. In any event, Mr. President, members of the court, the bilateral agreement is irrelevant to the present proceedings since it can only supplement the Vienna Convention. It cannot modify the Vienna Convention, nor does its text or content suggest that purpose to dilute Article 36 of the Vienna Convention. I mention this only because in one of Pakistan press communications, Pakistan alluded to this bilateral agreement. Moreover, this 2008 agreement, Mr. President, is not registered with the United Nations under Article 102 of the Charter, and therefore, under paragraph 2 of Article 102, this agreement cannot be invoked before any organ of the United Nations. Therefore, Pakistan cannot invoke this agreement before this court, undoubtedly this court being the principal judicial organ of the United Nations. Thank you, Mr. Chairman. May I now request you to invite Mr. Harish Salve, who will present India's observations in detail.
Merci. Je donne la parole à Monsieur Harish Salve, Conseil pour la République de l'Inde.
Honorable President, esteemed members of this court, it is once again an honor for me to appear before this court to represent my country as its counsel. I express on behalf of my country gratitude for having fixed this hearing at such a short notice. I want to commence by assuring this court that the situation in which we find ourselves is grave, it is urgent, and it is for that reason that we have sought the indulgence of this court for a hearing for the indication of provisional measures. I shall, Mr. President and esteemed members of the court, first give you a brief overview of the facts and then address you on the following 4 issues. The jurisprudence of this court as to the principles for indication of provisional measures, the prima facie case as to the jurisdiction of this court to entertain India's application, the prima facie case of violation of the Vienna Convention on Consular Relations 1963, and finally, I would state the nature of the provisional measures that India seeks. The Republic of India, I shall be referring to it as India, has moved this application under Article 40 of the Statute of this Court, seeking relief from this court to remedy egregious violations of the Vienna Convention on Consular Relations 1963. I shall be referring to it as the Vienna Convention. It is against the Islamic Republic of Pakistan, who I shall be referring to as Pakistan. An Indian national, Mr. Kulbhushan Jadhav, whom I shall refer to as Jadhav, was allegedly arrested on the 3rd of March 2016 and has been in custody. He was tried by a military court in Pakistan and has been convicted and sentenced to death, which sentence was confirmed on 10th of April 2017. It is not in dispute that India has made innumerable requests since March 2016 for consular access. Pakistan admittedly did not provide consular access. India claims that the rights of the individual and the rights of India under Article 36 of the Vienna Convention have been violated all along from the time of the alleged arrest of Jadhav. Pakistan did not inform the consular post of India about the arrest of Jadhav at the time of the alleged arrest, and India received information of his arrest only on 25th March 2016. Despite India's requests, Pakistan has denied consular officers the right to visit Jadhav. They have refused to communicate to the consular officers the charges against Jadhav and the evidence and other material adduced against him in the so-called trial, so as to enable them to arrange for his legal representation. The denial of access to Jadhav has resulted in consular officers of India being unable to arrange for legal representation of Jadhav and to assure themselves also of his safety and his well-being in custody. In a press briefing of 17th April 2017, the Director General of Inter-Services Public Relations allegedly asserted that Jadhav was not entitled to consular access. We have a copy of the press report, which we annexed to the application as Annexure 7, which refers to the briefing but not this assertion. We now have another press report in a vernacular newspaper, Jahan, Pakistan, of 18th April 2017, which evidences this assertion. India, Mr. President and esteemed members of the court, has applied to this court for redress of its grievances relating to these violations of the Vienna Convention, and by way of relief has sought measures that would constitute adequate restitutio in integrum. Until such time as the application filed by India can be adjudicated upon by this court, India has also sought indication of provisional measures that would ensure that the sentence is not executed. If the provisional measures are not granted, the application would be rendered infructuous, and it would bring about a situation that the court may find itself unable to grant effective relief as sought by India. I now address you, sir, on the principles for the grant of provisional measures. Commonly referred to as the Legrand case, this court clarified that orders of provisional measures pursuant to Article 41 establish binding obligations. The court formulated the threshold for provisional measures in Costa Rica and Nicaragua in terms of what I call the plausibility standard. This court said that provisional measures would be granted, and I quote, if it is satisfied that the rights asserted by a party are at least plausible. End of quote. Finding that the rights claimed by Costa Rica were plausible, this court went on to observe, and I quote, whereas at this stage of the proceedings, the court cannot settle parties' claims to sovereignty over the disputed territory and is not called upon to determine once and for all whether the rights which Costa Rica wishes to see respected exist or whether those which Nicaragua considers itself to possess exist. Whereas for the purposes of considering the request for indication of provisional measures, the court needs only to decide whether the rights claimed by the applicant on merits and for which it is seeking protection are plausible. The standard of plausibility was reiterated in Belgium and Senegal, where the court observed that, and I quote, whereas at this stage of the proceedings, the court does not need to establish definitely the existence of the rights claimed by Belgium or to consider Belgium's capacity to assert such rights before the court, and whereas the rights asserted by Belgium, being grounded in a possible termination of the Convention Against Torture, therefore appear to be plausible. There have been 3 instances in which this court has entertained applications arising from allegations of breach of Article 36 of the Vienna Convention. The case of Paraguay and United States of America, which is the first of the cases relating to violation of the Vienna Convention. The request of Paraguay for indication of provisional measures was decided by this court on 9th April 1998. Paraguay instituted proceedings against the United States of America on 3rd April 1998 on allegations of violations of the Vienna Convention and sought indication of provisional measures by way of an order by court that the government of the United States take measures necessary to ensure that the Paraguayan national, in relation to whom proceedings were brought, be not executed. This court enunciated the standards by which such a request for provisional measures would be decided. It observed that, and I quote, on a request for the indication of provisional measures, the court need not, before deciding whether or not to indicate them, finally satisfy itself that it has jurisdiction on the merits of the case. But whereas it may not indicate them unless the provisions invoked by the applicant appear prima facie to afford a basis on which the jurisdiction of the court must be concerned to preserve by such measures the rights which may subsequently be adjudged by the court to belong either to the applicant or to the respondent, and whereas such measures are only justified if there is urgency. Unquote. The court found that the circumstances of the case required it to indicate, as a matter of urgency, provisional measures as provided for by Article 41 of its statute. The second case, relating to violation of the Vienna Convention, was brought by Germany against the United States of America, known and cited as the Legrand case. On 3rd March 1999, this court indicated provisional measures pursuant to an application filed by Germany. This court reiterated the principle that generally interim measures would not be ordered in the absence of, and I quote, irreparable prejudice to the rights which are the subject of the dispute, end of quote. The court held that the execution of the German national, Mr. Walter Legrand, and I quote again, would cause irreparable harm to the rights claimed by Germany in this particular case, end of quote. This court also observed that, and I quote again, measures indicated by the court for a stay of execution would necessarily be provisional in nature and would not in any way prejudge findings that the court might make on the merits, end of quote. The court indicated that the United States of America should take all measures to ensure that Mr. Walter Legrand is not executed pending the final decision in the proceedings before the court. In the third case relating to violation of the Vienna Convention was brought by Mexico against the United States of America, known as the Avena case. Mexico sought relief in relation to 54 Mexican nationals who were on death row in the United States, and in respect of whom Mexico asserted that they were arrested, detained, tried, convicted, and sentenced to death by competent authorities of the United States in proceedings which did not comply with Article 36 of the Vienna Convention. The relief that was sought by Mexico was in the nature of restitutio in integrum. The application was filed by Mexico on 9th of January 2003 for indication of provisional measures, and the apprehension on which these measures were sought was that the three nationals could be executed